Regina DeMeo, and with me today is Keith Rosa, who is a litigator in Montgomery County that helps families when their children get in trouble. So, thank you for being on the show, Keith.
Thank you for having me.
Thankfully, I have an 8-year-old, so he's not in trouble yet.
Okay.
But, so I want to start by asking, is this something that, only less affluent families have to worry about, or, kids that get in trouble? Does this impact everybody?
All kids get in trouble. It doesn't matter what side of the tracks you grew up on. The richest families to the poorest families. Kids get in trouble. They sometimes they get a little rebellious. Sometimes they hang out with the wrong crowds, but they do get in trouble, and you have to be able to react appropriately as parents and be able to help them if they do get in trouble.
Okay. So, let's start at the beginning. Like, how does a parent deal with the situation when their kid gets in trouble?
Right. Well, I guess it depends on how old the kids are.
Okay.
If they're under the age of 18, it's going to be a juvenile matter, for the most part. Some juveniles can be charged as adults. A juvenile matter, when a child is a juvenile, well, children are juveniles, obviously, they can't be found guilty or not guilty. They can only be delinquent or not delinquent. And the difference really is, the feeling is that a child can't be found guilty of anything, but it also, the terminology is effective as it is because, when a kid is going to college or applying for a job, the question is, have you ever been found guilty of anything? Well, if they have a juvenile record and they were found guilty, then they would have to say, well, yes, I was found guilty, even though it's expunged. But if you're not actually found guilty, you're just found delinquent, and that's not part of the question. You can say, no, I was not found guilty of anything. The process for juveniles, much different than for adults. If you're charged as a juvenile, usually the Department of Juvenile Services in Montgomery County will have what's called an intake meeting, where they'll bring in the parents and the child and say, look, this is what the complaint is. This is what the police say you did. Let's talk about this. And a lot of times they'll kind of divert the matter away from the courts and say, look, I think this can be dealt with outside of the court system, and let's see what we can do to make matters right and to get you on the right track. Other times, when it's a lot more serious, they'll send it to the state's attorney's office, and they will have to prosecute the child in juvenile court. And if that happens, the child could be facing time in a juvenile detention center, mental health facility, or they could be just doing community service, restitution. A lot of times, and this is a concern for parents, if you have a juvenile that causes damage to property or steals something or causes any kind of economic loss to another person, the parents can be held liable for that loss directly.
So, like, the kid, makes a mistake and, burns somebody's car, for example. Yeah. All of a sudden, I'm going to be responsible for that car.
The value of the car, correct,
wow.
As their parent, right. So there's the juvenile portion, and then you've got the young adults. And nowadays, kids that turn 18, it doesn't necessarily mean that they are mentally an adult yet. And a lot of times they're still living with their parents.
Huh. But they can vote.
They can vote.
Yeah.
But
they don't have to go to school if they don't want to.
Correct.
Right.
Or they may be in college and living with their parents during the summers, or maybe in a local school and living with their parents year-round. But they're still living with their parents, and then they may get in trouble. And I think the most common types of trouble that kids over the age of 18 get into, underage drinking. They're over 18 but under 21.
Not 21, right.
Possession of paraphernalia, drug paraphernalia. I think those are probably the two most common, at least in this area, Montgomery County.
Now, why is it possession of paraphernalia as opposed to, possession of pot?
Right. They're two different things. The paraphernalia would be used to smoke the marijuana.
Right.
But a lot of times officers, when they say pull over a group of kids that may have a bowl or some other kind of paraphernalia in their vehicle, they'll make the choice as to what to charge them with. If there's a little bit of marijuana, maybe they won't charge them with possession. They'll just charge them with possession of paraphernalia.
Okay.
And not possession of marijuana.
Does everybody in the car get charged? Because, what if I'm in the car and I'm like, well, it's not mine. I didn't even know that was there, right? So I shouldn't get charged at all.
Right. Well, that's a very fact-dependent question. But generally speaking, if you're in the car with other occupants of the same car and there is, say, there's drugs or paraphernalia within your reach, even if you're not the driver and even if it's not yours, say it's just under your seat, that doesn't mean you won't get charged.
Wow.
The police aren't there to kind of determine who in the car was in possession of that particular piece of paraphernalia or the drugs or anything else like that. They may charge everybody and say, look, you're all saying it was the other person's.
Right.
You're all going to get charged, and you can fight it out in the courtroom.
So do they get a piece of paper, or when they get charged, what does that mean? Does that mean they actually go to some detention center?
Well, it depends on the charge.
Okay.
For example, for possession of paraphernalia, they'll usually just get a ticket and a court date,
Okay.
essentially in the mail. They'll get a court date later. And that court date, at least in Montgomery County, and for possession of paraphernalia and or underage drinking, their ticket and their court date will really be what's called an intervention, an opportunity for an intervention. Okay, and they will go to the courthouse. They'll go to a courtroom, but there won't be a judge there. There's going to be a bunch of people from the state's attorney's office,
Okay.
prosecutors, and then a bunch of people from a program. It's the Montgomery County, Maryland Department of Correction and Rehabilitation. It's a diversion program. It's run by a woman, or she's the supervisor, Nan Regan, who's a wonderful person. And what they do is they allow kids who maybe have gotten their first underage drinking ticket or their first possession of paraphernalia ticket. They allow them the opportunity to take part in an intervention program. And that intervention program will allow them to not have to go to court and to get a conviction. The whole matter will be expunged from their record if they complete the program. They won't have an arrest on the record, and they won't have a conviction. That's very important for kids that are in college.
Oh, yeah.
It's very important for parents who have kids in college and kids that are going to need to get a job, that they don't have a conviction on their record. And so this program, for example, for drug paraphernalia, the program is called IPSA. It's the Intervention Program for Substance Abusers.
Okay.
And what it'll do, it involves classes, a bunch of drug rehabilitation classes, essentially, about the dangers of drugs and alcohol, and also community service. They'll have them do 24 hours of community service through the people that run the program or through any other recognized Montgomery County community service program. And it's effective. They'll have them paint over graffiti, pick up trash,
Nice.
for 24 hours, and that's a lot of time. And sometimes it can be 48 hours, depending on what the charge is.
But it's consecutive, or you mean it's like over a period of a month or something?
You have to complete it within a certain amount of time,
Okay.
About a month. Sometimes it's a little more. So they'll do it on weekends. Maybe if they have summer jobs, the kids will do the work on weekends. When they want to be hanging out with their friends, well, they can't. They've got to do this community service. They've got to take these classes, and it will. The effect of a program like IPSA or ACS, which is Alternative Community Service, that's usually for people that get the underage drinking tickets.
Okay.
The effect of those programs is to create such an indelible memory in these kids' minds, so that if they're put in that situation again in the future, where they're in a car, like you said,
Right.
with other kids that may have drug paraphernalia, or maybe they're in a situation involving underage drinking, they're going to remember what they had to do the last time they got caught, and hopefully they'll make the right choice the second time. And not
Well,
take part.
if they don't make that right choice, like that IPSA program is only available once, right?
Yes, normally, for the most part. And again, it's fact dependent, but they usually will not allow people, for example, to take part in IPSA if they have other charges that other convictions on their record.
Oh.
Yeah, and if they've already been charged and have already taken part in the IPSA program, and they get charged again and want to take part in the IPSA program again, they probably will not be allowed to.
Got it.
Yeah.
Now, is this a process that the child's supposed to navigate on their own? Do their parents get involved at all? Should they get legal counsel right away, or wait until a hearing? When do you think that people should get involved?
That's a good question. I think it's fact dependent, but for the most part, the parents obviously should be involved, and a lot of them will say, "Well, my child's 18; they make decisions on their own,
Right.
and they should go through this on their own." Although I've found that parents that get involved and kind of help the 18-year-old through, or the 19-year-old through the process, it helps the child get through. And I call them I call the person a child,
Right.
but over the age of 18, they're not very, for the most part, very mature yet. They may think that the situation isn't as serious as it actually is, and they may, skirt through it and
Right.
may not finish it. And if you don't finish the IPSA program, and you don't abide by their rules, then they drop it, and you're going to have to go to trial. they'll drop the opportunity for you to be in the program. So parents kind of need to stay on their kids. And I found that some parents, unfortunately, will say, oh, underage drinking or possession of paraphernalia, not a big deal. And they'll let their kids know that. Yeah. And while in the parents' minds maybe it's not a big deal, it is a big deal because it still would be a conviction if not for these programs. And if it happens again, it will be a conviction on their record. So it's a very big deal. Makes sense.
Yeah, and I guess, do you have parents say, well, they don't have the money, I don't feel like I should have to put the money up front for my kid. Like, what do they do then? Like, do you maybe suggest that they pay the parents back? Is that something people can do?
Yes, and you don't always need an attorney for these types of cases, underage drinking or possession of paraphernalia. Sometimes you do, sometimes you don't. You should, depending on the facts, call an attorney and at least talk to them. And if there's not going to be an attorney involved, it will be less expensive. But the IPSA program, the ACS program, they cost money.
Right.
And the child may not have the money to complete the program. Parents really should pay the money and have the kid pay them back as part of their punishment. So that's my opinion on the matter. I don't think, if the child can't pay, I don't think the parents should just let them go forward and go to trial when they're given this opportunity. But,
right. Yeah. Maybe what is the range in fees? Like if you get an attorney involved.
Right. Well, for an attorney? Well, it depends again on the facts, but it could be anywhere from $1,000 to $4,000 for a case like that. It depends on the attorney too. It's not very, because unfortunately, if there's a drug paraphernalia charge, there may be other charges as well.
Right.
So just because your child, for example, has a drug paraphernalia charge doesn't mean you should automatically think, oh, we don't need to get an attorney if there's other charges too. The situation can be very complex and it may involve multiple court dates. So it depends again on the situation. But the IPSA fees, the ACS fees, I think if my memory serves me correct, I think it's about $150 program fee for ACS, for IPSA, and then I think if you want to take online classes as opposed to classes in person, I think it's an extra $55. And then there's some other costs involved as well. So.
Okay. So it sounds like, as long as you address the issue right away and don't ignore it, it's not the end of the world.
Right. And a lot of parents will say, oh my gosh, my child has gotten into this kind of trouble.
I'd be pretty devastated.
My straight A student, has possession. Well, it does happen to everybody, and the immediate reaction is anger, and you're on your own, that kind of reaction. But that needs to you step back and think about the situation, and everybody makes mistakes. And if you react correctly to the mistake that your child makes, then it's probable that the child won't make that mistake again.
We're going to take a short break, and then we'll be right back. Thank you.
I got no pulse for losing him.
Sergeant, he's in VFib.
Shock him.
Drives it around all the time. Just had a few drinks. This can't be happening.
Are we clear?
Clear.
You just buzzed.
Just buzzed. He didn't tell us that, sir. You're right. This isn't happening. He'll be fine.
I feel good.
Really?
No, not really.
Buzz driving. Maybe we should stop acting like it's no big deal.
Shock him.
Welcome back to Making It Last. I'm Regina DeMeo, and with me is Keith Rosa, and we've been talking about some of the troubles that kids get into and how we can deal with them. So thank you, Keith, for being here.
Thank you.
So now let's talk about drinking while driving, right? So I don't know, is there a difference between DWI and DUI? Because I don't know the difference, honestly.
There is. There is actually a difference, and there are two different statutes that actually cover them. You've got driving while under the influence, which is the most serious of the charges, and there's driving while under the influence per se. It's a legal term, but per se essentially has to do with if you submitted to a breathalyzer and you blew over a .08, then technically you would be guilty of driving under the influence per se. Then there's driving while impaired, which is a lesser charge. Still drinking and driving, but it's to a lesser extent. And people ask me, what is the difference? What's the difference between driving while under the influence and driving while impaired? I think there's a lot of different answers to that, but I think there is no right answer.
It's bad overall.
It's bad no matter what. The penalties are different. For driving under the influence of alcohol, if you're convicted, It's 1 year and/or a $1,000 fine in Maryland.
Can you opt to just pay the $1,000?
No, it's up to the judge. It's sentencing.
Okay.
Yeah. You can't choose your own sentence if you're convicted. And then DWI, driving while impaired, is 2 months and/or a $500 fine. So big difference. Big difference in sentencing.
Right.
A lot of times in this area, Maryland, people that get DUIs are between the ages of 18 and say 25. They're going to bars. They're going, places with their friends, and they're drinking.
Right.
And a lot of times, I found kids, maybe they're 21, will be out with their friends at a bar, and their friends will be really drunk. And they'll think, well, I've only had a couple drinks. I'm going to be the responsible
I'm the
one.
most sober, right?
I'm the most sober. I'll drive home.
Right.
Well, you would still be drinking and driving, regardless of how sober you think you are, if you happen to blow over a certain blood alcohol level. 0.08, as I mentioned.
Well, can't you
before.
just refuse the breathalyzer?
Oh, you can do whatever you'd like.
Okay.
You could certainly refuse a breathalyzer, but there are penalties for doing that.
Oh.
For example, when you get charged with DUI or DWI, you're obviously going to have to deal with the courts because it's a criminal charge.
Okay.
But you're also going to have to deal with the MVA. Okay, it's
2 separate
Yes.
hearings?
There would be two separate. You could have a hearing with the MVA, and it involves your license, because having a license in Maryland is a privilege.
Right.
It's not a right. And once the MVA finds out that you had to take a breathalyzer after you got pulled over, and you blew, say, a .08, for example, over a .08, you'd be facing a 45-day suspension just for blowing a .08, regardless of whether or not you ever get convicted of the charge, just for blowing over a
45
.08.
suspension, you mean like you can't drive for those 45 days?
Correct. And if it's over a .15, it's a 90-day suspension. And back to your question before, if you refuse a breathalyzer, it's a 120-day suspension. And there's some other problems that go along with it. Flat out. So it's obviously much more serious than a 45-day suspension, 120 versus 45. It's a lot more days without a license.
Yeah, it's like 4 months.
Correct, 75 more days.
Right.
So it's serious. And plus, if the state's attorneys want, and this is on the criminal side now, they can actually charge you with refusing a breathalyzer if you do. That's an extra charge that can be added onto your other charges that you've received. And normally, after when you get pulled over for driving drunk, you would get a number of tickets. You can get the DUI ticket, DUI per se, DWI ticket. Then there will probably be an underlying charge, the reason why you got pulled over in the first place, whether you took a right on red when you weren't supposed to, or you rolled through a stop sign, or you were speeding.
Or the cops saw you swerving.
Swerving, that'll be your other ticket. So you already have 4 serious tickets,
Right.
criminal charges that you're going to have to deal with. You don't want that extra one for refusing a breathalyzer.
Yeah, that makes sense.
Now that changes if it's going to be your second or third or fourth DUI.
Right.
Then the differences aren't that severe between suspension time and what you're ultimately facing in court. So if you refuse, it may not be that different from actually blowing. But for your first one, and for a lot of kids, it will be their first one.
Right.
When they're 18 to 25, it'll be their first one, and they'll be scared, and it's very costly. We were talking about attorney's fees before. You're talking about for DUI, DWI, $3,000 and up. To $5,000 to $6,000 just for attorney's fees. And
So
then
you can't go to one of those like little programs and pay a fee and do a little intervention and you're done?
No,
Oh.
no IPSA, no ACS. However, Maryland does have an alternative route. It's not an intervention program, but if it's your first DWI, and you have an attorney, and your attorney works out a deal with the state's attorney's office, with the prosecutor, say in court, where client will plead guilty to driving while impaired, which is the lesser of
the 3
of the DUI charges, right? So it's 2 months and/or a $500 fine. Before that even happens, if you have a good attorney, the attorney will have your child go into alcohol classes. Okay, and there's a lot of great programs in Montgomery County, alcohol programs, that can range from 4 weeks to 13 weeks to 26 weeks. And if your child can get into that program and take part in those classes, when you're trying to tell the judge during sentencing what kind of person your client is and how this is only the first time that they've been in trouble, and look what they're doing to make sure that this doesn't happen again, i.e. take alcohol classes, do some community service, things like that, then the judge has the option at that point to give the child, and it could be the adult, the young adult,
Right.
What's called a probation before judgment.
The PBJ.
The PBJ, which I think a lot of people in this area have heard of.
Yes.
Usually only
It's
get
not
them
peanut
once.
butter and jelly.
Not peanut butter and jelly. No. It's a PBJ, and basically what it is it's they find you guilty of that particular charge, DWI for example.
Right.
But then the judge will strike the finding of guilt and allow you to be placed on probation to complete your alcohol and or drug classes.
Okay.
Because driving while impaired charge can also involve drugs. It's
Right.
not just alcohol. Complete your classes, complete your community service. They have, a lot of times judges in this area will have the defendant go to the Mothers Against Drunk Driving Victim Impact Panel.
What is that?
It is a panel that's run by Mothers Against Drunk Driving, which everybody's heard of that group. They're a fantastic group. And they basically bring in people that have been affected in very bad ways by drunk
like
drivers.
a victim.
A victim, somebody who's lost a child, somebody who's lost a family member, to come in and talk. Somebody that has driven drunk and has caused some kind of severe pain or some kind of loss. And they'll come in and talk to a panel of people that are facing these charges or have been placed on probation because of these charges, and say, look, this is what can happen if you do this again. And you're lucky that you're sitting here and talking about this instead of having to go to a funeral or something like that. So,
Right.
Those impact panels, they're very effective, and a lot of times that'll be part of probation, as I said. And if the child completes all of that, okay, then the finding of guilt will be struck. They will have a PBJ.
It's not a conviction on your record.
Exactly. It's not a conviction on your record for college, for jobs. And you can say when you're asked, have you ever been found guilty of a crime, you can say no.
The answer's
Because
no.
even
Okay.
though you were technically found guilty, that finding of guilt was struck by the court. And you were allowed to complete probation and kind of get off with, I guess you can say, a slap on the wrist, but very expensive slap on the
Yeah.
wrist. A lot of very time consuming. You will have lost your license for a significant amount of time.
Can you get more than one PBJ? Like, can you just keep racking them up? No.
For the most part, no. It's happened, I'm sure, but for the most part, judge will only give one. I call them your one get-out-of-jail-free card. You have this one opportunity to use this, and they don't use it for everything. The statute that the Maryland legislature passed for probations before judgment only applies to certain offenses, one of which is DUI, DWI. So that's kind of how that works, and that's, again, talking about it from the parent's perspective. Child gets a DUI, DWI, again, very angry, may want to withdraw, say, I can't believe he put himself in that situation. I taught him better. I taught her better. But you kind of have to gather yourself, rally around your child, find an attorney that you're comfortable with, and get them help, and get the process started. Alcohol classes, drug classes, community service, before you get to court. And a good attorney will make sure that the process starts before you get to court. So that,
Why is that better than just waiting and saying, like, I'm just going to wait to see what the judge has to say?
well, it's personal opinion, but I feel that judges are more responsive to somebody that is already taking steps
Okay.
to kind of fix what they've done and to show that they're remorseful. If you show up to court and you say, it's been 7-8 months since I got this and I haven't done anything,
Right.
then in my opinion, a judge may be a little more, may want to penalize you a little bit more. It's not always true.
Right.
It's in my opinion, but that's usually what happens.
Let me ask you this. So what happens if, whether it's a divorced couple or even an intact marriage, but the two parents have totally different views? Like,
Yeah.
you have one, maybe like me, that would be like, oh my God, let me help you. Let me
Right.
find the best attorney. Let me
Right.
get the best program. And then you have another parent who's like, well, he created this mess. He should fix it himself. You have two completely different views. Do you see that?
Definitely see that a lot. However, my client will be the person with the charges,
Right.
the child. And when I meet with the entire family unit, I'll give them a broad overview of maybe what to expect. But then I want to meet with the child separately, and I'll ask the parents to leave. And at that point, I will get the real story as to what happened from the child. Because, with all due respect to parents, kids don't always tell them the full story. Whether they're ashamed, whether they're scared. They won't always tell parents the full story. So
Right. They want to gloss things over.
get the full story from the kid, and then I'll talk to the parents. And if there's differing views as to how to go forward, if it involves money, one wants to pay, the other doesn't.
Right.
They need to work that out. But the speech that I will give them is you need to put aside your differences if you can, and focus on your child and your child going forward. And then you can continue to argue and fight after the court trial. But for now, try to work together.
I mean, is
on
that
his or her
because it's
behalf.
distracting for the kid, or I
Yeah.
mean, is it a message that you want the child to have that the kid is being cared for by both parents?
Well, yeah.
Is it for court appearances?
No, not
for
for,
court
not for that. And I won't bring
Okay.
that up in court. I just think, in my experience, I've been doing this for 8 years. In my
Yeah.
experience, these young adults, these kids 18 to 25, they do better during, the time period from when they are actually charged with a DUI or DWI, and the time when they have to go to trial if they have some support.
Yeah.
It's tough to go through by yourself, whether you're 50 or whether you're 18. But I think it's a little more difficult for young adults that are 18. They're more like kids, and they need help from their parents. Even 21-year-olds, kids in college, they need some help from their parents. And I think it's important for a family unit to kind of, even if they're not a unit because of divorce, they still need to kind of get together and help their child. So.
Have you found that maybe this is like a wake-up call for the whole family sometimes? Like once they rally together, they wind up realizing there's some other problems that they need to address?
Oh, yes.
Yeah.
Oh, yes. A lot of times there's a lot of fingers being pointed, but for the most part, everybody always thinks, oh, this can't happen to me. This can't happen to my family.
Right.
We're straight-A students, and, myself and my husband, we're quality people in the community. Well, it can happen to anybody. And when it does happen, that's kind of when you take a step back to reflect and say, well, what could we have done differently, and what can we do going forward? And in that sense, it sometimes can be very helpful. A lot of people have come to me years, after a certain charge and said, wow, if I didn't get that wake-up call, who knows where I would be? And parents say the same thing. If my child didn't get that wake-up call, who knows where they would be? So a lot of positive things can come out of a very initial negative situation.
Oh, yeah, that's great.
Yeah.
So thank you so much for coming on today and helping us understand this. If people want to contact you, where would they contact you?
Well, the name of my law firm is Abrams & West. My phone number, 301-951-1545. You can also send me an email. It's krosa@awsdlaw.com.
Great. Thank you so much, Keith, for coming on today.
Thank you for having me.
And thank you all for watching. If you have any show ideas or want to be a guest volunteer, please contact me at genxmarty@gmail.com. And once again, thank you for tuning in, and see you next week on Making It Last.